Hey, what is up, YouTube? It is your boy Evan coming back at you with another video, right? So today was pretty insane as far as Supreme Court decisions. You know, normally these things are sort of metered out over a couple of days, but not today. No, the Supreme Court is coming to you with decision after decision after decision, and all of them are looking really good for us. So I thought it'd behoove us to go over the SCOTUS blog, kind of read about some of these decisions and talk about it. But before we get into that, I would really appreciate if you can meet me at my reciprocal tariff. That's right, you get to watch this video, and in return I'm going to get your like, comment, and subscription. Sounds fair? I think it's fair. I'll give you a little second to do that. Did you do it? All right, I appreciate that. Let's go ahead and get into this, right? So SCOTUS blog, Amy Howe writes, court allows parents to opt out their children out of school lessons involving LGBTQ plus themes. Now, as a little synapse of this, some schools would read LGBTQ themed books and allow parents to opt out of that material if it didn't seem to align with their religion. If it were up to me, these schools wouldn't be reading these books, but I like that the schools were offering an option to opt out. That was until they removed said option. So some parents challenged it, it went up to court, and the Supreme Court held in a 6-3 decision that parents should have an option to opt out of these LGBTQ books. But let's actually read what they write. The Supreme Court on Friday ruled that a group of Maryland parents have a right to opt their elementary school aged children out of instruction that includes LGBTQ plus themes. Elementary school age, bro. We're not even talking high school. Little kids that shouldn't even really know what sex is, but we're promoting to them lifestyles that are centered and cored within sexual activity. But I digress. By a vote of 6-3, the justices agreed with the parents who are Muslim, Catholic, and Ukrainian Orthodox. Imagine the worlds that have to move to align up all these different religions, right? Well, to be fair, 2 of them are Christian, 1's Muslim. That the Montgomery County School Board's refusal to provide them with an option violates their constitutional right to freely exercise their religion. Awesome. Writing for the majority, Justice Samuel Alito acknowledged that the courts are not school boards or legislators and are ill-equipped to determine the necessity of discrete aspects of a state's program of compulsory education. But he emphasized that when the parents seek here is not the right to micromanage the public school curriculum, but rather to have their children opt out of a particular education requirement that burdens their well-established right to direct the religious upbringing of their children under the Free Exercise Clause of the First Amendment. Based. I loved it. Now, of course, this was a 6-3, so 3 of these justices dissented, and I'm pretty sure you can imagine which ones, right? Justice Sonia Sotomayor dissented in an opinion joined by Justices Aaliyah Kagan and Ketanji Brown Jackson. Probably mispronounced that. I do not care. Sotomayor warned that Friday's decision threatens the very essence of a public education because it strikes out the core premise of public schools, that the children may come together to learn not the teachings of a particular faith, but a range of concepts and views that reflect our entire society. They don't reflect our entire society. They reflect a very small amount of our society, a minority of our society, if you will. And it's topics that are just wholly inappropriate for children this age. The case comes to the court from Montgomery County in Washington, D.C. suburbs, with nearly 160,000 students enrolled during the 2024-25 school year. It is one of the nation's largest school systems, and it is one of the most religiously diverse counties in the United States. The dispute stems from the county school board's 2022 approval of books featuring LGBTQ plus characters for use in its language arts curriculum. Oh, you thought your kid was learning about reading? No. They're learning about putting D's and A's, or V's to V's. One book, Uncle Bobby's Wedding, tells the story of a little girl's reaction to her uncle's same-sex wedding. Another book, Pride Puppy, describes a puppy that becomes lost during a pride parade. Oh, sounds like a horror book to me, man. Poor dog, seeing those people dressed up as dogs. But I think you guys can gather from this article so far that the school were in the wrong, and the courts recognize that these parents have a right to bring up their children with their religious background, and if that religious background does not allow for such practices, they should be allowed to opt out of this material. So I'm not going to go further into the article, but you guys got a sense. That is one W for us today, but that is not the only one. Far from it, actually. Courts allow Texas law on age verification for pornography sites, right? So it seems like common sense that if you are not an adult, you shouldn't have access to this material. Now, the groomers will tell you that no. Why verify age, right? We should be showing this stuff to kids in school. In fact, this is what they tried to do, right? With that book, Genderqueer. In a major First Amendment decision, the Supreme Court on Friday upheld a ruling by a federal appeals court that allowed Texas to enforce a state law requiring pornography sites to verify age of their users before providing access. By a vote of 6-3, the justices ruled that the U.S. Court of Appeals for the Fifth Circuit should have used a more stringent standard of review, known as intermediate scrutiny, to determine whether the Texas law passes constitutional muster. But as Justice Clarence Thomas, the GOAT of the Supreme Court, wrote for the majority, the Texas law passes that test. The power to require age verification is within a state's authority to prevent children from accessing sexually explicit content, Thomas concluded. Seems like a no-brainer, right? Justice Aaliyah Kagan dissented in an opinion that was joined by Justices Sonia Sotomayor and Ketanji Brown Jackson. Of course, it's the three. They're all for degeneracy, hedonism, and overall decadence. She contends that Texas law should have been reviewed using the most stringent standard known as strict scrutiny. No, absolutely not. To give you guys a little tidbit, right? Strict scrutiny revolves around race. Intermediate scrutiny is used for things such as gender discrimination, age discrimination, sexual orientation discrimination. That's what intermediate is for. Strict scrutiny is for race. Anywho, Texas law, known as HB 1181, compels websites to verify the ages of their users if more than 1/3 of their site's content is sexual material harmful to minors. HB 1181 passed in 2023, but before it could go into effect, senior U.S. District Judge David Allen Ezra temporarily blocked the state from enforcing it. Ezra agreed with the challengers led by an adult industry trade group that the law likely violated the First Amendment by interfering with adults' access to protected speech. Goodness gracious, right? Oh, guys, no, we need to protect expression. That's what this is. It's a freedom of speech thing. You don't want to violate the freedom of speech of these porn stars from expressing themselves to children. No, goodness gracious, right? So, without going any further into it, you guys get the crux of it. Texas just wanted these people to verify the ages so kids aren't being exposed to this harmful material. But no, that's too much. That's unreasonable. While we're at it, we should also stop IDing for liquor. Stop checking driver's license for people driving. No. Full range, man. Who are you to impede on my expression? Goodness gracious, man. These people are evil. But that is just the second win of the Supreme Court. So the next one, justices reject challenge the structure of HHS task force that supported providing coverage for HIV medication. The Supreme Court on Friday rejected a challenge to the structure of the Department of Health and Human Services task force that made recommendations about which preventative services, including HIV medication, insurers must cover at no additional cost to the patient. By a vote of 6-3, the justices ruled that members of the U.S. Preventative Services Task Force, an individual panel of 16 volunteer experts, were properly appointed by the Secretary of Health and Human Services and did not need to be nominated by the President and confirmed by the Senate. See, I'm tired about us making these appointments and the left screaming about these appointments because this is nothing new. It's not anything new. We're not appointing people to actual paid offices, which do need to be nominated by the President and then confirmed by the Senate. No, these are volunteers. These are people we recognize as experts in the field, and they're giving us their time to make the country better. This doesn't need to be confirmed by the Senate. If money was going into these people's pockets, Yes, 100%. But that's just not the case. Justice Brett Kavanaugh wrote for the majority, emphasizing that the structure of the task force and the manner of appointing its officers preserved the chain of political accountability that was central to the framers' design of the Appointments Clause. The task force members were appointed by and are supervised and directed by the Secretary of HHS, and the Secretary of HHS in turn answers to the President of the United States. There, accountability is set. These people answer to the Secretary of HHS. HHS answers to who? The President. Accountability is set. Looks good to me. In fact, the court agrees that it looks good. Justice Clarence Thomas dissented in an opinion joined by Justices Samuel Alito and Neil Gorsuch. Thomas argued that under our Constitution, appointment by the President and Senate confirmation is the rule. Appointment by a department head is an exception that Congress must concisely choose to adopt. The framers established that this rule is to ensure that the president is accountable for the selection of officers in the executive branch, and it is the law whether we agree with it or not. Wow, now that took me for a turn. I did not expect Clarence Thomas to dissent on this, but he doesn't dissent from a place of ideology. He is a constitutionalist, and he believes that is the interpretation of this. I personally disagree. I agree with the majority of the court that these are not positions that need to be nominated and confirmed. These are volunteer positions. It would be different if they were paid. Then I would totally agree. But personally, I just don't see it. Now, with that said, I still revere Clarence Thomas as the GOAT of the Supreme Court. The day he resigns or passes away is going to be a day that I am in much pain. But I just disagree with him on this. But I understand where he's coming from. So, that was another win. We got this task force up, and they're going to help continue to improve the Department of HHS. And frankly, I don't think we should be paying for these medications. I don't think we should be forcing insurers to be paying for these medications. I understand that Africa has an HIV problem, but it's up to you to take care of yourself. If you're having unprotected sex, you take up the liability of possibly having a child, possibly contracting an STI or an STD. That is something that you made the choice to do, to participate in, and those consequences may follow. But let me know what you guys think. This one, I think, has a little bit more nuance to where I could understand why people may be on the other side of it. But personally, I don't think we should be paying for that medication, especially for a foreign nation. Supreme Court sides with Trump administration on nationwide injunctions in birthright citizenship case. Also written by Amy Howe. Give an applause for Amy Howe for doing all this coverage on the same day. Superb work. The Supreme Court on Friday grants the Trump administration's request to partially pause rulings by 3 federal judges that had blocked President Trump's executive order ending birthright citizenship. That is, the guarantee of citizenship to virtually anyone born in the United States. By a vote of 6-3, the justices repudiated the concept of universal or nationwide injunctions, which prohibit the government from enforcing a law or policy anywhere in the country. The justices did not, however, weigh in on the question at the center of the 3 lawsuits before the court, whether the birthright citizenship order itself is constitutional. So let's take a look at this. Most of the America First movement has been pushing for this for a while. The 14th Amendment followed the Civil War, in which slaves were made citizens. And the way they did that was the 14th Amendment. If you were born in this country, you are an American citizen. That was the intent of it. Now, that has been taken to a larger interpretation of anyone born in the United States becomes a citizen. And for a long time, that's gone unchallenged. But now we're taking it back and we're looking at what was the actual intent of the 14th Amendment. And you always have this stuff kind of go back and forth with a lot of these amendments, right? There's the people that use the Second Amendment where they say, well, the intent of it was for there to be a well-regulated militia and everyone is the militia, so therefore everyone has a right to bear arms. But then you have the people that are for gun restrictions say, no, it says a well-regulated militia, you are not a part of the military, you don't need it. I think it's important that we really look at what these laws were intended to do. If you have a law that says no selling liquor after 11 and the store closes and reopens at 3, that's still the nighttime. And if they start selling liquor again, you're kind of defeating the purpose of the law, right? The intention was there to be no liquor sold after a certain point of night. But if you close and open up a few hours after, you're kind of defeating the purpose of that law. But someone that is a strict verbatim person, they are going to say, no, they're following the law. They are not violating the law. But someone that looks at the intention of the law is going to see that, well, we didn't want them selling liquor at night. They closed at 11, reopened shortly after, and started selling liquor again. That doesn't count as a new day. So I think with laws like this as well, the amendments, we need to look at what was the actual intention of these laws. And that's where Trump is coming from and a lot of America First is coming from. Now, these judges, they tried to block his decision, which that in itself is the actual legal question that the Supreme Court is answering. Can a district judge make these sweeping decisions that impact the entire nation? And what the court has found was, no, it's too much authority for these smaller courts to be completely shaping U.S. policy or blocking it. The Trump administration will also likely be barred from enforcing the order, which will not go into effect for 30 days against the individual pregnant plaintiffs who have challenged it. But the court's opinion by Justice Amy Coney Barrett left the open prospect of additional litigation in the lower courts about how much more the injunctions should be narrowed, as well as the possibility of class action litigation to challenge the order on behalf of groups of plaintiffs who were not part of the litigation before the court but would be affected by the order. You know, a lot of people have been saying this is the Amy Coney Barrett redemption arc, right? She ruled against the majority conservative court in a few decisions. And a lot of people were basically saying, oh, she's a DEI hire. She's a DEI hire. No. Let's get that straight, right? Now, Ketanji Jackson is definitely a DEI hire because Biden sought out a black woman. Full stop. That's what he wanted, a black woman. Trump didn't say, I am going to appoint a woman. He said, I'm going to appoint who I think is best for the job. I think Trump's the best president of my lifetime. I don't always agree with absolutely everything he says and does. We're allowed to have nuance. Amy Coney Barrett, in Trump's opinion, was the best person to appoint. That doesn't mean he has to agree with everything she does. That doesn't mean I have to agree with everything she does to recognize she earned that position. So I would just challenge my fellow conservatives, before you start waving around the accusation of DEI, take an objective look. In most decisions, she has voted in the right way. You're not always going to get that. Just like how I think Clarence Thomas is one of the best, if not the best, Supreme Court justices we've ever had. He made a decision that I didn't agree with. That doesn't mean he's a DEI hire. Barrett acknowledged arguments that the universal injunction gives the judiciary a powerful tool to check the executive branch, but federal courts do not exercise general oversight of the executive branch. They resolve cases and controversies consistent with the authority Congress has given them, she emphasized. When a court concludes that the executive branch has acted unlawfully, the answer is not for the court to exceed its power to. Completely agree. So, to wrap things up, 4 court decisions, 4 of them are favorable. I think that this is such a great step in the right direction for our country, culturally, legally, and it's going to allow for us to continue to make America great again. But let me know what you guys think. Do you agree with these decisions? What would you have voted differently? Let me know where you are in the comments. Do you agree? Do you disagree? And if you found this informative, please drop a like, drop a comment. It helps the channel grow. I really appreciate it, guys. With that said, I'm Evan. This was the video, and I'm out. Peace.